Perfect. So that should hopefully be working. So thank you very much for the nice introduction. Thank you for having us here today. It's such a wonderful space to be in, and it's lovely to see people in person and online. So I just want to briefly outline some of the principles and choices raised by decertification as an imagined future law reform project. And we're specifically talking about the law in England and Wales here because it's own jurisdiction. So these principles are all based on the research we've undertaken as part of the Future of Legal Gender project over the last 4 years. And the content of these principles has also been revised through stakeholder discussions over several months. And our aim for these principles is really to stimulate wider public discussion. So these are essentially meant as a prompt about decertification and whether it would be beneficial as a progressive legal measure. Like Davina said, our project is not one of advocacy. So the principles identified here are posed tentatively to explore what abolishing legal sex and gender status might entail in practice, if one were to think about it as an actual law reform project. As Davina said, decertification may in general be a candidate for slow law reform, sort of worth gradually advancing, but not yet ready for implementation in the present moment, given the other changes that would need to take place in order for this to be a viable progressive project. And some of these changes, as we've noted before, sort of are happening on a local level. They're happening by different kinds of bodies, ranging from quite informal groups to NGOs to local government organizations. So firstly, here are our aims for what decertification should entail, and kind of what law implementing decertification would need to address or be attentive to. And this would really be to abolish a legal system of certification that treats sex and gender as a legal status that's registered as a quality of individuals, primarily on birth certificates. But at the same time, decertification would also have to contribute to the dismantling of hierarchical structures based on gender that tend to encode an institutionalized difference in society. And thirdly, which would be intended to support the lives of people whose gender predominantly leads them to experience marginalization and other forms of disadvantage and exclusion within society. And finally, decertification should contribute to the undoing of social injustices and inequalities more broadly, because, as of course, I think everyone in this seminar is aware, often these things link very closely to class, disability, race and ethnicity, religion, in all kinds of very complicated ways. So decertification could not be a standalone project. As I said, our principles are trying to prompt wider discussion. So our principles also include, and you can see this if you're here in the room, in our final project report, we've left in some questions as part of these principles to explore the different choices that could be made within a decertification framework, as these don't automatically follow from decertification. So we've really tried to combine different sets of concerns about equality and inequality. For the sake of time today, I'm just going to focus on the first 6 of our principles, as these are sort of the core principles, but there are more if you would like to look at our final project report. And firstly, and perhaps most straightforwardly, our principles would argue for that the legal registration of sex and gender is abolished. Sex and gender status would therefore then no longer be legally established or assigned, primarily through birth certificates. Therefore, laws such as the Gender Recognition Act 2004 that provides a mechanism for changing one's legal sex on one's birth certificate would also become redundant, because if there's nothing to change, why would you have a law to change something? And one possible addition here is that sex as observed at birth could continue to be recorded in aggregate for planning and statistical purposes, but not on birth certificates. But these kind of amendments proposed here would mean that it would no longer form part of an individual's legal status. Existing legal registration of sex and gender through birth certification or gender recognition certificates would then no longer carry legal effect. So it would also affect people who already have a birth certificate that listed their sex. And our second principle would be the introduction of a new ground of gender inequality law. Gender to us remains a legally important term for tackling social subordination, discrimination, violence, and other injustices, including through equality law. So legal use of the term gender then also encompasses inequalities that relate to embodied forms associated with sex. The current grounds of gender reassignment and sex in the Equality Act 2010, our main framework of equality law in this country, would be merged to form a new ground of gender as a protected characteristics in the terms of the legislation to tackle discrimination, harassment, and the public sector equality duty as it currently stands. Recognizing gender as a ground of inequality and discrimination, i.e. the basis on which inequality and discrimination take place, does not require individuals to be legally assigned to a specific gender category. Employers, service providers, and others cannot require people to dress or behave differently on grounds of gender. And employers and others should therefore not enforce a narrow dress code, for example, that everyone must wear trousers, avoid jewelry, have short hair, and so on, unless this is done for reasons of health and safety, of course. Legally protecting diversity should also counter appearance-based codes, including in relation to dress and hair, such as those that are often adopted by schools in this country, which tend to stigmatize, exclude, and discriminate on ethnic and religious grounds, as well as on grounds of gender. One question this raised for us was whether gender itself should be legally defined. The Equality Act 2010 currently adopts different approaches to different grounds of inequality. In some cases, it works by defining member classes that together comprise the overall categories. So for example, for sex and sexual orientation right now, it simply lists what is part of those categories. In some, it describes component elements of the categories. So for example, for race, it notes language and nationality, for instance. As gender's meaning is currently in flux, as current debates very much show, it may be better to leave its definition to evolving case law, as has been the case with religion and philosophical belief, for instance. However, since the scope of gender as a legal ground is currently in dispute, a non-exhaustive list of component elements may be helpful. This could include bodily sex, gender non-conformity, norms and expectations relating to women and men, and social transitioning. Part of our thinking and context of this principle is that equality law is currently asymmetrical and operates on the assumption that the group that is subject to inequality is fairly static. However, we wanted to also acknowledge that who is the subordinate group may change over time. So it's not always going to be static, and law should be, in that sense, flexible and able to accommodate social changes. And our third principle is one of gender-neutral legal drafting. So current gender-specific terminology in law includes mother, female, father, male, woman, man, opposite sex, same sex, and so on. Building on existing practice in legal drafting that is already happening right now, this principle proposes that where it's necessary to use pronouns to refer to individuals in legislation, gender-neutral pronouns, so they, them, theirs, should be used, except, of course, where this leads to or contributes to structural inequality, other injustices, or a lack of legislative clarity, because, of course, law needs to be intelligible. In legal context where it's important to name physical processes with gendered meanings, this can be done without using explicitly gendered language. So, for example, using the terms gestational or birth parent rather than mother or woman. This recognizes that people other than women can also become pregnant, and would also be aligning with other law reform efforts currently happening around these areas. And our fourth principle is the legal right to organize gender-specific provision for specific purposes. And by that, we mean that gender-specific provisions, activities, and membership criteria would remain legally valid as long as these are in place to address social subordination, unfairness, violence, or harassment. For instance, thinking of women's domestic violence shelters, which formed a part of this research project, or community provision for non-binary and agender young people, for instance. Some questions and potential choices that would have to be made in this context are that the gender-specific provision should also be permissible in other circumstances. For instance, firstly, to establish or maintain personal dignity in conditions where mixed gender provision is perceived, either by the individual involved or by existing social norms, as demeaning or embarrassing, as for example, in certain hospital boards. And secondly, should it be allowed when it's done by informal or small organizations that are not in receipt of government funding, even when these are not intended to address social subordination, unfairness, violence, or harassment, for example, should still be permissible to run a men's tennis club, for example. And our fifth principle is one focusing on self-identification. So it would mean that decertification introduces a presumption of self-identification in determining gender category membership, in line with certain other legal categories such as sexual orientation and race, where of course no legal status exists. However, this also recognizes that A, unlawful discrimination may relate to physical embodiment and or other people's perceptions in ways that diverge from self-identification. And B, that taking up gender-specific opportunities or benefits where they exist through affirmative action, for instance, may also require demonstrated evidence of disadvantage based on gender or based on a capacity and readiness to represent subordinate and marginalized gender experiences, if we're thinking of parliamentary shortlists, for example. C, that gender-specific provision may draw on alternative or supplementary criteria to self-identification, for instance, in relation to organization staff, users, or volunteers, for example, relevant work experience, assessing suitability, and so on. However, underpinning all of this would be the idea that evidentiary requirements that undermine a person's well-being and dignity are never acceptable. And one question